Good morning. The podium is yours.
Your Honor, my name is Edward Autry. I represent the appellant Hannah Blevins. I would like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
Your Honor, this case is simple. In my opinion, the court should reverse the trial court and vacate the December 5th order, 2023 order.
Let me ask you a question before we get too deep into
Yes, Your Honor.
this. Has the trial court ever ruled on your motion to vacate?
No, sir, Your Honor. It refused to.
I'm not sure what you just meant by what you just said. Perhaps you can explain that. It refused to.
We put in our brief and trying to be somewhat delicate, but I'll try to be as candid as I can. This particular trial court, we would file the motion, we would request a hearing date, and there was a refusal to grant our hearing date on multiple levels, which is referenced more particularly in the brief. So the answer to the question is we never had a hearing on the motion to vacate. I think we had also filed a petition for a TRO that was denied without reasons. But no, there was no hearing on our motion to vacate the default order.
And obviously, the reason I asked that question is it goes to our jurisdiction to adjudicate this appeal. We've got a pending motion, timely filed as well as I can tell from looking at the pleadings, a timely filed motion that is provided for by the rules of civil procedure, which keeps this judgment from becoming final. So consequently, we don't know what the trial court's going to do. So that leaves us in a bit of a quandary, I believe.
I don't disagree with Your Honor. The difficulty from the trial, our standpoint, Your Honor, is, and I referenced it on page 3 of our reply brief, trial courts are required, as the court pointed out, to mandate, it's tendency on mandates that trial courts provide reasons for either granting or denying each of those motions. That's the Bell versus Todd case. Difficulty from our standpoint, Your Honor, is when the refusal to schedule a hearing date and then the entry of various orders, one of which closed the estate, we're left with little choice but to file a notice of appeal with this court and bring the issue before the court. But I don't disagree with the court's assessment of the procedural posture.
Was the estate closed before or after the motion to vacate was filed?
After.
All right, the December 5 order that you seek to vacate, is that the one that removed your client as a personal representative?
Yes, it removed my client as a personal representative, and it removed my law firm as counsel for the estate as well, Your Honor.
All right, now after the trial court removed your client and you filed a motion to vacate, but after that the decedent's mother filed a motion to close the estate, and the trial court granted that motion, and the estate has been closed.
That is correct, Your Honor.
What remains to be done in the estate if we were to reopen the estate?
Well, without having the benefit of knowing what the replacement executor did or did not do, I can't speak to what may or may not need to be completed, Your Honor, with respect to the estate administration. There's many things that go into it. I know that my client, who served as the executor for in excess of 4 years, properly tended to the estate administration, filed the annual accountings. There's many things that go into an estate administration.
But there were no assets, were there?
There was the right in a federal court wrongful death action.
Well, that's a pretty easy accounting.
It is, Your Honor, but because my client was removed, we are without the benefit of knowing the specifics of that action because...
Well, the action is a wrongful death action.
That's correct.
And the proceeds from any recovery in that do not go to the estate. They go to the beneficiaries specified in the statutory scheme. So what is there for the estate to do when the wrongful death proceeds don't belong to the estate?
Well, that's why I may disagree with Your Honor to some degree. I understand the statutory scheme in a wrongful death action, Your Honor, but since the inception of this estate administration as well as the federal court wrongful death action, the entire proceeding was brought by and through the estate. The wrongful death was brought, filed, litigated, settled by and through my client, Ms. Blevins, as the administrator of the estate. The estate is open. There are expenses that were incurred during the estate administration. There are attorney's fees to be addressed by various attorneys, including Mr. Wells, who's here today. So those are all issues that are right for the estate to address, because as the court can see from the pleadings, there is some disagreement regarding the attorney's fees.
I don't see any outstanding motions to pay attorney's fees.
There are not, Your Honor, but that's part of the estate administration process when my client was the named plaintiff in all actions, federal court actions, settlement documents, et cetera.
All right, thank you.
Yes, Your Honor. So we would ask that the December 5, 2023 order be vacated, as well as the May 15, 2024 order closing the estate and discharging the personal representative. We put in our brief, but I think it's three very simple issues, Your Honor. It is under Rule 55 of Tennessee Rules of Civil Procedure, when a default motion is granted or requested, it's a 5-day minimum written notice requirement under the rules. The rule says the movement shall provide 5 days written notice before a hearing is held on that motion. That was not done. It is undisputed that that was not done. Number two, Your Honor, under Tennessee Rule of Civil Procedure 8.04, any allegation against an executor must be proven. And again, because a trial court speaks through its orders.
But this is not really an accusation against an executor. It's to simply remove the executor and appoint the decedent's mother. There was no claim for relief against the executor, no claim for money, no claim for damages.
Well, with all due respect to the Your Honor, there was a relief requested. The relief requested was the removal of the executor.
Yeah. And what property right did your client have to be the personal representative?
I don't know that there is a right, but
Yeah. So
since the inception of the case, she was requested to be appointed by all beneficiaries of the estate, and she served in that capacity. And case law in the estate world, just because a beneficiary becomes upset with an executor's choice in an estate administration doesn't give them valid cause for the executor's removal. My client serving as the executor was simply removed without any cause, without an opportunity to be heard, without a hearing as required under Rule 55, and without evidence as required under Rule 8.04. Further, Your Honor, there was no evidentiary hearing, which Judge Stafford referred to earlier, and there was no compliance with the local rules that we've put in our brief. But in the Shelby County local rules, if there's going to be a contested matter, you have to appear before the trial court, you have to obtain a special hearing date, you have to enter an order setting that hearing date. So for multiple reasons, Your Honor, from a purely procedural standpoint, my client never had the opportunity to even defend and refute the allegations regarding.
Well, your client had more than a year from the filing of the petition to file a response to the petition for her removal, and she never did.
Well, respectfully, Your Honor.
That was her opportunity to be heard.
Well,
at least the first opportunity.
Well, the first opportunity that the court can see from the appendix to our reply brief, the opportunity from predecessor counsel, Mr. Bradley, pursuant to Rule 1103, we provided the required notice under Rule 11, which presumably is why he corrected and amended his petition. And
the Rule 11, the letter you sent to counsel is just a notice that we might seek Rule 11 remedies, but you never did that. But more importantly, you never filed a response to the petition for removal, which in essence concedes the issues. But then they did file an amended petition for removal and replacement, and your client didn't file a response to that either.
That's correct, Your Honor, because with all due respect to the court under Rule 8.04, my client doesn't have to. My client can simply show up at the hearing, have an evidentiary hearing, offer testimony, and refute every single...
You're saying your client has no responsibility to file a written response to be entitled to a hearing?
Under Rule 55, no, Your Honor, because what my client could have chosen to do under Rule 55, when the required written
Talking about
notice...
default judgment rule?
Yes, Your Honor.
All right, well, the notice in Rule 55 deals with a party against whom relief is sought.
That is correct, Your Honor.
There's no relief being sought against your client.
Again, I must respectfully disagree with the court. The relief that was sought against my client under the amended Wood petition was her removal as the executor of the estate, and that was granted by default under Rule 55. And there was
no monetary judgment against her. There were no sanctions against her. She was simply replaced by a successor personal representative.
That is correct, Your Honor.
Okay, all right.
But there's been a complete failure by the trial court as well as opposing counsel to comply with multiple rules of civil procedure. And for those reasons, Your Honor, I respectfully ask the court to vacate the December 5, 2023 order, as well as the May 15, 2024 order that closes the estate and discharge the personal representative.
All right, thank you, sir.
Yes, Your Honor.
We'll hear from you on rebuttal.
Good morning.
Good morning.
May it please the court, Murray Wells, Shelby County Bar. Here today is representing the FLE in this matter. I think this case is just inexplicable in terms of why we're here and how we got here. In both the probate matter and in the...
Before you get into that, you're here. Do we have jurisdiction?
Well, a brief was filed and we filed a reply, and so we're here. And for our perspective, we're here
I understand what you're saying, but that's not my question.
I understand what your question is. I'm not sure whether you do have jurisdiction or not based on the lack of an entry in order, but I will explain to you what happened.
Do we have a final judgment?
We do have a final judgment.
How so?
What's that?
How so?
How do we have a final judgment?
Yes, sir.
What happened was Judge Townsend ordered Hannah Blevins and Ed Autry to appear and to respond with respect to the motion to set it aside, and they did neither again, which was just consistent with the pattern of absolutely doing nothing.
To appear, on what date did the court set the hearing?
The court set the date to March 11th, 2024.
And you say
At 11
he
o'clock.
ordered them to do so. Is the order requiring that in the record?
I don't know that, I haven't seen it in the record.
Have you seen the order at all?
I was there.
I understand that.
yeah.
Have you seen the order? Because courts speak through their orders.
That's right, I understand, Judge.
So I'm just asking, is there an order?
I don't think there is an order.
Okay.
There's probably an email directing counsel to appear. Nevertheless,
Wait a minute. So you're saying the order's not in the record, or there was no order?
I don't know that he did an order. I haven't seen it in the record.
Okay, I thought you said the court ordered them to appear.
It was an oral order.
In other words, it was a statement from the court saying.
Basically, the court said, you need to be here, your client needs to be here, and you need to have responded to the amended petition to substitute.
And that communication set a specific date and time for the hearing?
It did.
And that's in the record?
That specific date is in the record.
Is
Volume 1, number at 148.
Is that a communication from the court? Or is that a communication between the attorneys working with the administrative assistant of the court to agree to a mutually agreeable date?
It was a direction of the court from the bench.
That's
When did-
not what I'm asking.
Maybe I'm missing what you're saying.
Well,
On
I-
February 27th,
What I'm asking is there a written email? Is there something? Okay, and where is that?
No, I'm agreeing with the question. I'm not answering in the
okay.
affirmative.
I thought you were saying there was one.
I don't know that there is that order with those directions. I'm telling you what happened from the bench. And so you can consider it or not consider it. I
It
understand.
appears there was a lot of communication of some sort going back and forth between whomever. But I've yet to see an order saying, we're going to hear this on this date. Does one of those orders exist?
The order continuing the hearing on the motion to vacate is in the record at 148.
And what does that
was
do?
a March 7th order. The trial court continued the hearing on the motion to vacate to that date,
To which date?
to March 11th, 2024. On March 7th, the court, there was an initial hearing that appellant didn't show up at. That was scheduled for March 4th. Appellant didn't show up. The hearing was rescheduled due to the appellant's absence. That's in the record at 146 and 147. They didn't participate. On March 7th, the court entered the order that I'm talking about, continuing the hearing on the motion to vacate until March 11th of 2024.
And so this all resolved itself on March 11, 2024.
As far as we're concerned, it resolved itself. I think it was resolved before that. I think it was resolved when the court substituted the administrator of the estate.
How then, I've got a May 15, 2024, excuse me, wrong order. There are too many orders here. I've got a December 5, 2023 order granting petition to substitute personal representative by default. It says it was heard on the 20th day of November 2023. That's not the same date as March 11.
No, that is their motion to vacate the default order.
No, this is the order granting petition to substitute personal representative by default. This
Yes.
cause came to be heard on the 20th day of November 2023.
Yes, that's 92 in the record. I
sorry?
understand. That's number 92 in the record. I understand that the default had been granted. The March dates of 2024 that I was talking about were the setting of his motion to vacate, which I believe to be part two of his arguments. One is that under the 5560.02, it should be set aside. And the second is that the motion to vacate was never heard.
Okay, I misunderstood you. I apologize. You were talking about the motion to vacate.
I was, Your Honor.
Okay, so what happens is there an order from this March date of 2024 on the motion to vacate?
That's the order I said I don't believe it exists, but at that point, you know, the transfer of the administration had already occurred back in December.
How can that be when there's a motion that's filed that keeps the order from being final?
Well, that's a question for the judge.
Yes, it is.
Certainly. But I don't know that you have to send it back and answer it, because I don't know that it matters. And I think Judge Clement, you were exactly on point with some of your questions earlier about why we're here in the first place and who has an interest in this matter and why Ms. Blevins is so interested in this estate. And that's kind of where I want to use some of my time to kind of go back and explain how we got here and why that default happened. Hannah Blevins alleged that a conflict existed between herself and Ms. Sneerly. And she alleged that both in the federal court and in the probate court. And it wasn't that there might be a conflict or that there's a potential conflict. And this happened well before the motion to substitute in both matters. They never explained what the conflict was. And more importantly, I think for you, is the conflict was never resolved, whatever conflict they had. And it wasn't perhaps we have a conflict, is we have a conflict. And so at that point, everything has to move forward without them because they've said they can no longer do it, right? That's what the conflict says. In the federal piece, we were under a scheduling order. Judge Norris required us to mediation by a date certain. They had said they're conflicted. We moved forward. We resolved the case with defense and Ms. Sneerly because they said they had a conflict and were no longer participating. After the case settles and the notice of settlement is filed, the 41 notice is filed in federal court, then magically they want to withdraw their motion to be removed because of the conflict. And they also magically, the conflict has resolved itself somehow in probate as well. So now we're here. That was never resolved. But that issue was never resolved. So then Ms. Sneerly says, well, we need to get this forward. There's a point to all this. And that estate was denied their money for years. And that estate was denied their money based on a complete inaction of the appellants. They refused to respond to the petition to substitute. And then they refused to respond to the amended petition to substitute. All the federal court stuff is in the record in the amended petition, so you can see what's going on. You can understand how that happened. Then they refused to participate in getting the motion set. There is no excuse for the neglect. There's no excuse to not respond. And there certainly isn't an excuse for when they just declined to show up despite having an email, acknowledging an email that the matter was set. Nobody showed. Ms. Blevins is an attorney. She's married to Mr. Autry. Neither one of them showed up. So what do they want? The estate is closed. The beneficiaries are the beneficiaries. There's no issue there. He's presented you nothing today to say why this family should go back and relive this issue, that there was any wrongdoing by Mr. Bradley, who represented, in terms of the estate and the funds in the estate. That isn't present here. What are we doing?
Let me ask you a question. Sir, I believe that as an officer of the court, you're standing here and representing these things to us correctly. But let me ask you this. Aren't all these details that you are going through and all these instances that you are going through basically to justify what you believe is the correct removal of Ms. Blevins, were those not things that should have been items of proof for the judge, the trial judge, in looking at and analyzing a petition to remove her?
They were in the amended, and all those exhibits are attached.
But I understand you've got them in a petition, but are those not things that should be proof to a judge, to a trial judge first? You're wanting us to take notice of all these things and to basically use those to justify the outcome here. And are those not things that a trial judge should have been presented with proof of first at a hearing under the rules of procedure?
I believe that the judge can take judicial notice of orders of the federal court, and all that is
Well, there's a lot of things you're sitting here telling us that are standing here telling us that are not necessarily contained in orders of the federal court. You're giving us the backstory. You call it the, quote, backstory. Are those not things that should be proven to the trial judge before you're asking us to look at those and let the trial judge make a decision on whether any of that was correct or not, or whether make the findings of fact?
Well, we tried to do that, Judge. We tried to have a hearing. We filed a petition. The appellant filed a petition. The appellant had hearing dates. I was there to testify. In most of the things that I just alleged regarding the settlement and the conflict issues, those are all contained in Judge Norris's order that is attached to the amended, the supplemental petition to remove. So the idea that shouldn't have there been proof rather than taking it to fault, that would have been ideal. I think the result would have been exactly the same. That's speculation, obviously, but at the end of the day, we tried to get there. They refused to let us go there. And because they refused to allow that hearing to happen, it happened by default, rather than a full, robust evidentiary hearing about all the things I'm talking about.
When you say it happens by default, would it not have been extremely simple to have said, here's a court date, here's an order setting this for hearing, signed by the judge?
Which part?
Any of it.
Maybe. I mean, the judge instructed Mr. Bradley to send an email out telling Ms. Blevins of the hearing date. Mr. Autry acknowledged that, that's on the record, and they just didn't show up.
Well, the emails that are attached, which I assume are part of the record, or we wouldn't have them anyway, indicate that there were conflicts on these dates and that Mr. Autry was attempting and gave alternative dates for hearing. And there was never a response to that.
In the record, starting at 133, 135, and 138, appellant's counsel acknowledged receipt of the email on November 16th, but both appellant and appellant's counsel failed to attend the hearing either remotely or in person, or notify the court of any scheduling conference. There were other dates.
Who are you reading from? What are you reading from there?
This is my brief, I'm citing the record.
Oh, okay, sure.
I'm giving you
Well,
the record citation.
I've got the emails here, so.
Right. So you've got the emails
I do have
on
the
November
emails.
16th.
And I've had Mr. Autry's responses to Mr. Bradley and so forth that are contained in the record.
Right.
It would seem to me it'd be a very simple fix to say, we're going to have this hearing on December 1. Here's a court order that says we're going to hold a hearing on the motion to remove the personal representative on December 1, signed by the judge. Now, nobody can fuss with that.
I don't disagree.
That's neither here nor there.
I don't disagree, and I'm out of time.
All right,
Thank you.
let me ask a question, and you've got more time. Ms. Blevins filed a motion to withdraw in July of 2022. You filed a petition to substitute the personal representative on December of 22. And then you filed an amended petition for removal of Ms. Blevins in May of 23. Did any order get entered on any of these three? And I think one got entered, but there were three motions and/or petitions.
Obviously, there was no response to the motion to substitute because there was supplemental.
I'm asking about orders.
The only order is there was never an order on the conflict issues. Or never hearing, it was never set for a hearing.
Yeah.
And I think the reason for that is because they filed a withdrawal of conflict, which I'm not sure how you just cure a conflict by filing a motion to withdraw. So that's why there wouldn't be an order there. And then the order for default addressed the other two motions that were filed that you mentioned, the petition and supplemental petition.
So the withdrawal of conflict was filed before the order removing Ms. Blevins was filed.
That's correct.
Okay. And now, the proceeds from the wrongful death settlement, have they been dispersed?
They have.
And to whom did they go?
The beneficiaries of the estate.
And who would that be?
Shalonda Rose Nearly and everyone it's in the order. I can name the other family members.
Was she the only beneficiary?
She was not.
Okay.
There were, I believe, 3 beneficiaries,
I know
but it's in the order.
Her husband died, and I'm trying to think who else, but there were no children of the decedent.
Grandparents.
The grandparents, that's right, it was the grandparents, okay. All right, his parents, yeah, okay. All right, so is there anything left for the estate to administer?
I don't believe there's anything left for the estate to administer. I think the only thing is that there's money being held in escrow if there was a bill submitted by Hannah Blevins, which it hasn't happened at this point.
But that money is not being held by the estate?
It's not being held by the state. It's in my escrow account right now.
Okay, all right. Did any money ever come into the estate regardless of the workers' comp settlement? I mean, the wrongful death settlement?
No, all funds went directly from defense to,
Did the decedent have any assets to be administered?
there were no assets.
Okay, all right, thank you.
Thank you.
Rebuttal, Mr. Autry. Mr. Autry, if the decedent had no assets to be administered,
Yes, Your Honor.
then why are we trying to administer a decedent's estate?
Well, candidly, Your Honor, and I believe the record does clearly reflect this, Ms. Blevins, as the executive of the estate, engaged counsel and was the named plaintiff in the wrongful death action. And so contrary to Mr. Wells's general statement about everything that took place, that the proceeds went directly from the federal court to beneficiaries, he has bypassed the complete step of going through the estate. Now, here's the issue, is under the wrongful death statute, Your Honor, suit could have been filed by the heirs in the federal court.
Right.
There was issues to begin with that are more delineated in the probate pleadings, but there was a non-agreement among the beneficiaries, which is why the estate, if you look at all the documents, the estate was the named plaintiff in the federal action, the estate is the named plaintiff in the engagement agreement. It is the estate that they chose to run the proceeds to the
estate was the named
estate.
plaintiff, but it was on behalf of the heirs, the wrongful death heirs, right?
Well, it was on behalf of the estate, Your Honor, because with all due respect to the court, the estate is an entity. We don't,
Oh, I fully agree with that.
but we don't know at this point
Now,
if she
in
was
federal
removed.
court, was Ms. Blevins ever removed as the party plaintiff in the federal court
No, Your
proceedings?
Honor. No, Your Honor, and to follow up counsel's incorrect statement, there was never, we never refused to appear. As the court, as Judge Stafford correctly pointed out, in the record, there are emails where I was notified either the day of or the day before, you're ordered to appear on this date. And I think that it was a November 6th or November 7th email that I communicated not only to opposing counsel, but the trial court clerk, the judge's clerk, that said, I'm in Chancery Court in the same courthouse in an all-day contested hearing. I can't be available on this date. Give me an alternative date. Let's enter in order, you know. And I was happy to appear if we'd have been ordered to do so or had a particular date. But we never refused, and there's nothing to support those contentions that are in the record, as pointed out by Judge McGee. All the speculation and the innuendo that the opposing counsel has stated to the court is not in the record. There was just no compliance with Rule 55, 8.04, no opportunity to be heard. They just appeared, they had my client removed, and that was it. And candidly, Your Honor, I think it's also in the record from the federal court. The federal court deferred to the probate court for the disputed issues regarding the attorney's fees and the disbursement of funds. It's in the federal court order. I see that I'm out of time. I'm happy to answer any questions.
So the federal court litigation was resolved, settled, but the estate was the named plaintiff?
That is correct, Your Honor.
How did that get resolved without the participation of the personal representative?
That's an excellent question, and that's a question that has yet to be answered because we have posited that question. It's in our pleadings, it's in our brief. We still don't have an answer to that question, Your Honor.
All right, thank you,
Thank you,
Mr.
Your
Autry and Mr. Wells, for your arguments. We'll take this matter under advisement.
Thank you.
Call the next case, please.
Gladys Claire Bowen versus Michael W. Nelson, MD,